All right, good morning, everybody. My name is Mark Mormons. I'm the Senior Vice President of Entrepreneurship and Venture Development with the Arizona Commerce Authority, and excited to welcome you all to this morning's session of the Arizona Small Business Boot Camp. First, want to take an opportunity to thank all of our community partners. We wouldn't be able to offer this boot camp and all of the great content without support from partners like these from across the state, and we're excited to be working with them to continue delivering all of these quality resources for you. So what is it? The Small Business Boot Camp and Resource Collective is a daily boot camp designed to help businesses with 20 employees or less navigate the COVID crisis and prepare to return stronger now that the economy is beginning to reopen. It's a statewide initiative, again, with the support of all those community partners and many more. And it's daily, set to run through June at least, and then we're looking now to see kind of how we continue to provide these types of informational resources to you on an ongoing basis. This week, we've got some great content for you. On Monday, we had a session on building a business resiliency plan. Yesterday, we talked about how to rebuild consumer confidence. Today, we've got a great session on contracts, force majeure, and how COVID is affecting those things. Tomorrow, we have our safety session with the National Safety Council, the Arizona chapter. And then on Friday, we're going to be talking about how to use social media to announce your business has reopened as a marketing session. All of these sessions, I'll send a link in the chat. You can register for them on our bootcamp website, as well as watch past sessions that we've all recorded. Some quick updates on PPP. There's still over 100 billion remaining in the PPP funds. And so if you haven't applied yet, have been thinking about it, or you're working with lenders that are a little bit slow, we encourage you to still get out there. There's money to be had. Arizona has had over 75,000 small businesses receive some of those funds for a total of an $8.5 billion infusion into the state. So we're really excited about the support that Arizona businesses have gotten. Similarly, with the EIDL loans, we've had over 13,000 small businesses receive those for over $1 billion in funding. And we've had over 50,000 Arizona businesses receive EIDL advances. So we want to encourage all of our small businesses across the state that are still looking for that support to continue applying or to reach out because there's still money available. We'll also be having a session this coming Monday on updates to PPP forgiveness guidance. And so I encourage you to check out our website to register for that. Some new policies and guidelines were passed at the federal level that we're excited to kind of share new updates with you. In addition to this boot camp, we have several other programs and initiatives that are aimed to support small businesses. So we've partnered with America's SBDC chapters, and there you can find local business coaches, local lenders, as well as kind of functional expertise across accounting, marketing, and support for your business. We've also launched the Arizona at Work program, where you can go to get recertified, help find employees for your business, and kind of build out your workforce. And then we also have one of the best manufacturing Arizona MEP programs in the nation. We provide consulting and other services for manufacturers across the state. So I encourage you to seek out those resources as well. You can also visit the governor's site, arizonatogether.org, on all things COVID. And there you'll find additional individual and business resources to support you and your business during the COVID situation. We've also compiled and aggregated several guides for you. So whether you're a hotelier, restaurateur, retailer, there's all sorts of guides and resources available on our site as well as the Arizona Together site. And I'll post a link to that on our website as well. I encourage you to visit our site at azcommerce.com/COVID-19 for all the latest updates, statuses, resources, and guides as well. There's a lot of information there to support small businesses like you. So today I'm very excited to be introducing Dan Gauthier and Olin Lenitz from Rose Law Group. They're going to be speaking to us about contracts and how to kind of navigate any contractual changes as a result of COVID-19. So along the way, if you have any questions for them, feel free to use the Q&A tool at the bottom of your screen or in the chat box, where I'll be posting some links as well. So without further ado, I will hand over my screen to them and let them take it away.
Thanks, Mark.
All right. Thanks,
All right.
Mark. You guys see my screen okay? Looks like.
I see it.
Yes, looks great.
Perfect.
Awesome.
Okay. Well, so thanks for having us today. And we're going to be talking today about, as Mark teed up, force majeure and contracts as these things have changed and morphed in this new COVID world. So let's jump in. Let's start with just a little bit of background. You saw this bio a second ago. My name is Dan Gothier. I'm an attorney with Rose Law Group. I practice primarily real estate and business transactional law. So that ranges from commercial transactions, lots of real estate investment, development, and a host of business issues, business disputes, joint ventures, all kinds of stuff. Olin and I also host a podcast called The Rose Report. It's a biweekly podcast that endeavors to break down legal issues for non-lawyers. So similar to the content that we'll be talking about today, I encourage you guys to check that out if you're interested. And we'll have links to share at the end of this presentation as well.
Well put. And I also work for Rose Law Group. I'm in the litigation department, and I also do a little bit of criminal defense work. And I think the dichotomy between Dan and I, and you can see this as we talk about this, is you would use someone like Dan, a transactional attorney, at the onset of any sort of legal matter you have, creating the contract, creating the operating agreement, et cetera. And you would come to me, the litigator, if there's unfortunately a problem with whatever you're doing with your contract, there's a breach or you need to enforce some specific provision. And the way it applies to force majeure, as you'll see, is the better use you have of someone like Dan at the onset, the less likely you'll need to use someone like me towards the end of your legal endeavor. So that's kind of how our paths cross. Is, a lot of times you'll get, I wrote this contract for someone and now the party's breaching, I need you to sue them. And so that's where I come in.
And that doesn't happen too often, right? Because normally I try to make sure that doesn't happen.
Right. It's
at least that's
not,
the idea.
It's not, hey, Olin, I wrote a really poor contract. There's a lot of loose ends and holes in it, and now I need you to clean up my mess. No, it's not that.
Yeah. Okay.
Yeah, don't be discouraged from hiring Dan. So force majeure, as we just pointed out, it is a contractual provision, and it's both a creature of statute and a creature of common law. What that means is there's actually codified law on the books in Arizona defining what it is, but courts have taken that definition and then expanded or contracted it to narrowly fit how it should be applied. So first of all, Title 33, which is discussing property in Arizona, defines force majeure as an act of God or of nature, a superior or overpowering force or event or effect that cannot reasonably be anticipated or controlled. Kind of vague, but you kind of get the idea. It's something that is outside of the control of a party. In 2016, a Superior Court case actually defined force majeure more narrowly, as you can see, an equitable legal principle pursuant to which a party to a contract whose performance has been made physically and or economically impossible, or at least impracticable, due to circumstances totally beyond his control, can be given certain types of relief. So now it's getting a little more explanatory. There's an economic impossibility or impracticability. We'll talk about the difference in a bit, but it's, again, still something that's just out of the party's control, whether it's both parties or one of the parties. If you see, this is a 2016 case, in Title 33, I believe was 1970s when that was adopted. But the idea behind force majeure goes back thousands of years.
Yeah, and so the origins of force majeure, as Olin mentioned, they originated back in Roman and French law, and then in the mid 1800s were adopted into English common law. This was not a thing in the United States. It was not adopted or recognized legally until an 1883 Supreme Court case in the United States. This case was aptly called the tornado. And in this case, a ship owner, and we'll go through this just to illustrate exactly what force majeure is and when it might apply. A ship owner was hired to deliver some freight to a buyer, and before setting sail, the ship caught fire. The entire ship caught fire, and it was unable to sail. So obviously couldn't deliver that freight to the buyer. Pre-force majeure, right? So the contract didn't include language to address this situation. It did not include a force majeure clause, the subject of what we'll be talking about in just a moment. And so the court here was asked, what do we do? Who should bear the risk of loss? Who should bear the damages in this situation where we have an unforeseen and accidental fire? And what the Supreme Court did is they adopted the rule from the English case, as I mentioned earlier, a mid-1800s case. This case was called Taylor v. Caldwell. So I think this is about 20 years after it was adopted in England. And the Supreme Court came out with this rule and really adopted that Taylor v. Caldwell decision completely. And the rule was where there's an agreement of two contracting parties, and that agreement contemplates a specific set of circumstances to occur, and those circumstances can't any longer be performed due to no fault of either party, both parties are then excused from performance. So applied here, we have a unforeseen and accidental circumstance, the fire, rendering the boat unseaworthy, and the ship owner had no way to get the freight to the buyer. So again, specific set of circumstances can't be performed, and both parties were then excused from performance. The court rescinded or modified the contract to have both parties walk away essentially hands-free. And that case was the first instance of force majeure being adopted into American law. And it's sort of developed and grown from there, as Olin mentioned, through statute and through cases here in Arizona.
And as I talked about in the ARS definition, the statutory definition, it says act of God. And you may have heard this term before. It is a term of art. An act of God refers to a hurricane, an earthquake, a natural disaster, basically, something that's entirely, even if it's foreseeable, it's unpreventable. And I just think it's kind of ironic that this case called the tornado involves a fire, because had the tornado, which was the ship, been affected by a tornado, which is an act of God, the same exact analysis that the court reached in this case would have been applicable. And Dan and I were laughing about that the other day, that the tornado was very aptly named.
Exactly.
So force majeure today, why is it important and why are we talking about it now? I mean, it's been around for thousands of years, hundreds of years in the legal realm, and it's been in US law for 150 years almost now. So why is it important today? Well, it's important now because of the effect and the unpredictability of the coronavirus and how COVID-19 has impacted the way that it has been applied presently. So the force majeure clause allows a party to suspend or terminate the performance of its obligations when circumstances beyond their control arise, making performance inadvisable, commercially impracticable, illegal, or impossible. We've discussed, the history and the case law and the statutes. Now that's an easy, digestible definition for us now. The problem with it is, up until March of 2020, I think the overwhelming majority of contractual clauses, including the force majeure clause, were very boilerplate and broad. And Dan can speak to this more, having, dealing with contracts day in and day out. And he'll show you some examples that he's personally seen. They didn't cover, and they really had no reason to cover something like this, because it's very unprecedented. So specificity is crucial now, because without including something like the coronavirus in this very broad anticipated idea of things that can happen, you won't be covered whether it's whether your performance is affirmative or retroactive, and the force majeure clause, although there for this specific purpose, might not be applied to your contract.
Yeah, and I would just add as additional context here, you know, those of you on the webinar that have you know read a contract that you've signed, which you know I'm hopeful as a transactional lawyer that you do, but not everyone does. But you know, most commercial contracts and certainly consumer, you know, boilerplate contracts will include a force majeure clause. You know, so what we're talking about when we say that it's a common clause in most contracts, but it's boilerplate and ambiguous. I would say that is the overwhelming majority of contracts that we see. In the very recent history, this has become a hot topic because of COVID. But prior to that, force majeure was a clause that was inserted in contracts similar to, you know, a choice of law clause, which would allow you to choose, you know, Arizona law over other law, or you know, some other boilerplate provision in a contract. So, you know, this is, you know, most likely if you were to, you know, go into your documents here and pull a contract that you or your business has signed, you'd be seeing a clause that we're talking about here.
And more likely than not, that clause would not contemplate or be impacted by coronavirus.
Right. It would be ambiguous and broad. So Olin teed this up, but let's look at a couple of samples, and I'll say at the outset here that you know, don't try to memorize this or you know, dig into it too deeply on this slide. I'm going to read through it and you know, think about it as I'm reading through it, but we'll pull this back up in a second and break it down into digestible pieces. So,
well, and as a quick aside, I think it's important to point out that you'll see one, obviously this one's very long, and you'll probably see the next one, I'm guessing, is going to be very short. And that's not to say that length is always important in a contract. If you have something that's clear and direct, it doesn't have to be a massive paragraph like you're going to see here. So just because in the event of force majeure, it might be important to have a long and thorough one, that's not always the case.
Certainly not always the case. That's right. Yeah. We can often strip out a lot of unnecessary language. So this one here says, other than the parties' obligations under this agreement that can be performed by the payment of money, payment of rent, or maintenance of insurance, whenever a period of time is prescribed in this agreement for action to be taken by either party, such party will not be liable or responsible for, and they will be excluded from the computation of damages for any such period of time, any delays due to strikes, riots, natural disasters, acts of God, shortages of labor or materials, war, terrorist acts or activities, governmental laws, regulations, or restrictions, which are beyond the control of such party and cause such party to be unable to perform its obligations hereunder, defined as the force majeure events, except if the party otherwise chargeable with breach or default was negligent. The party shall notify each other immediately when a party desires to exercise its rights under this paragraph. So a mouthful. So as I mentioned, we'll jump back to that. So keep that in the back of your mind for a second. Okay, so sample 2, lot shorter, not necessarily worse, but in this case worse. So here's this one. Notwithstanding anything to the contrary contained herein, neither party shall be liable for any delays or failures in performance resulting from acts beyond its reasonable control. Okay, so that's you've heard 1 and 2. Let's break them down. So here's 1 again. And the question I want you to think about is you know, what's good about this clause versus the other? So why is it good? So first sentence here in the light blue, other than the parties' obligations under this agreement that can be performed by the payment of money, payment of rent, and maintenance of insurance. So what this is this clause excludes payment obligations from being covered by the force majeure. And what that means is it creates a carve out from the generally applicable force majeure protection. So this is almost always, and we probably should have said this at the beginning, but I'm going to say the word generally a lot. Don't take any of this as specific legal advice. We're speaking in broad strokes here, just trying to inform, and to the extent you actually need help with digging through these types of provisions and negotiating them, definitely reach out to a lawyer to help you with that.
But what is a bad force majeure clause, and we're very broad, and everything we're doing is not necessarily applicable to any specific person.
That's right. Well, and the reason for that will become clear in a second. So, as with this first clause, I say generally you want this in here because when you have a party that might be looking to exercise a right pursuant to a force majeure, so a strike, a riot, a pandemic, as we'll talk about, you do not generally want that protection to get that person out of paying money or maintaining insurance or other tasks that can be performed by paying money. So as a really simple example, let's say, we have a tenant and a landlord. The tenant's business is shut down due to or was, back open now, but was shut down due to the stay-at-home order. And what this carve out would do is remove the right of the tenant to say that the tenant is not going to pay rent or maintain insurance under its lease because of the force majeure event. Now, I said a second ago that you almost always want this, but sometimes no, and sometimes it's a point of negotiation, depending on who you are in the contract, and really depending on if you're the person that's performing by paying money or performing by acting is the bottom line.
So if we jump back to the tornado example, if the owner of the tornado found a different way to ship the goods, the person receiving the goods can't say, well, your boat burned down, I'm not going to pay you, because that event doesn't actually apply to him, because if this clause is there, because his performance is just the payment of money. He can't use that event affirmatively for himself.
That's right. That's exactly right. Yeah. Yeah. So let's look at the pink clause here. So the pink clause says, and there will be excluded from the computation of damages for any such period of time. What does this mean? So this means that the protections of the force majeure not only include performance of acts, but they exclude damages that might accrue during the time that the force majeure event exists from being asserted in any subsequent litigation or dispute. So in other words, if the ship owner, and going back to the tornado, the ship owner and the buyer are in that contract, and the buyer incurs some damages because he hasn't received his goods, and maybe he was going to use those goods on a project of his own, or resell them, or whatever it is, and he incurs damages because of that. This would exclude that from applying if he was to assert some future litigation or bring some dispute of any kind. So that's the pink. The green, this is the laundry list of possible force majeure events that I've defined at the end of this, and this is importantly a non-exclusive list. So really the definition harkens back to the last part here, which says that whatever the event is beyond the control of the party and causes the party to be unable to perform its obligations. So this is not an exclusive list. That's important to note. Okay, so orange. This is a really important one as well, that you won't see in the second example. And this, except if the party otherwise chargeable with a breach or default was negligent, means that if the person that is trying to invoke protections under the force majeure clause was negligent, or to the extent they were negligent, they're not entitled to protection as a result of that negligence. So back again to the ship example. If the tornado owner accidentally set his ship on fire or purposely did it, that would not be a basis for recovery or for relief, I guess. Yeah, suspension of performance, exactly, under a force majeure clause. And then lastly, the red section. This is going to require notice between the parties. Keep the lines of communication open as soon as one of those parties intends to exercise its rights under the agreement. So that's important as well, because that will hopefully, at least the idea is cap some of the potential harm and damages that results from a force majeure event.
And before you jump ahead, or now as you jump back, so we talked about why this is a really good clause, and I just want to point out that regardless of how good this clause is, it still might not be covered in the coronavirus examples, because there's nothing that really specifically talks about pandemic here. Now, a clever attorney might be able to convince a judge that it does apply because we talk about governmental laws, regulations, or restrictions which are beyond the control of the party, which would obviously be the executive order that Governor Ducey put forth closing non-essential businesses. So if you are essential and you have to stay open, this still doesn't apply to you. Even if you have employees who aren't coming in because they're scared for their health, or they have quarantine because of a family member that can't be exposed or can't have heightened risk, that might impact your essential business, but you still can't use it because the clause, at least, to suspend any performance, because you're not covered by anything here. But had you just slipped that word pandemic in, or viral outbreak, something like that, which again we're going to talk about will likely be the new trend, this still wouldn't cover you regardless of how thorough and well put this clause is.
Okay, so back to the second example. Here it is at the top of the screen. So what's weak about this one? So it doesn't exclude payment obligations. We talked about that. You may not always want that exclusion, but I can tell you that in my experience, that is absolutely the norm. And most interpretations of force majeure will at least there will be a strong argument to exclude that payment obligation, and it's going to be a hard point to negotiate out if you're trying to. What does outside a party's reasonable control mean? I don't want to say this as a blanket statement, but throwing the word in front of throwing the word reasonable in front of control in this case, I would say probably doesn't do you much good. It probably adds ambiguity. But despite that tidbit, I would say there's no laundry list, there's no examples, there's no context to explain what that means. And it's ambiguous. It could be interpreted broadly or very, very narrowly, which is what we don't want. We want certainty.
Right, and I just to jump back on that, someone reading this might say, well, Dan Olin, this says any event outside of control, that covers everything possible. And unfortunately, if you're trying to enforce it that way, what the court's going to say is it's going to look at the subjective intent of both people. And if one person says, no, I thought this meant this, and the other person says that, then there's not a meeting of the minds there. And that's required to have that term be interpreted the way you want it, which is, again, why specificity and narrowness is a lot more beneficial than just having a broad blanket statement that really doesn't say anything at the end of the day.
Yeah, and then you're going to have that fight in front of a judge, right? I mean, instead of meeting those minds at the outset, as you put it, you're going to have that same discussion later, right. But it's going to be in the context of trying to get protection versus negotiating your protection, right?
Exactly. It's cheaper, less time consuming. And even if you prevail at the end of the day, you have to go in front of the judge.
Right, right. So I guess the third point here is it needs to be tied, and this is along the same lines of what we just talked about. It needs to be tied to the expectations of the parties. There needs to be that meeting of the minds. That's the idea to create certainty. And then lastly, we need a laundry list, so to speak, to give context about what we're actually talking about here. There are some other points, such as, not including the negligence carve out, not including the notice between parties. And, those are important as well. I'd say that these are the fundamental issues, though.
So now that you know an example of a good force majeure clause and a weaker or bad one, what do we think is going to happen going forward? And I think you've heard us mention it already or allude to this, is that these provisions are going to get a lot more narrowly tailored to provide the exact protections that the parties want. And as Dan pointed out, if you're the party who's simply making monetary payments, you might not want such a narrow provision because you maybe don't want the other side to have relief any possible way that they can find. Whereas if you're the party who has, to build the house by a certain date, then you absolutely want to make sure that the other side, the one who's just paying you for that building, knows that if any of these things happen, these are beyond my control. These aren't anticipated. These aren't foreseeable. So I'm going to need extra time, or there's a chance that I may never be able to complete this. And both parties need to understand that so that there isn't that dispute once, unfortunately, that event or a event, unanticipated event happens. So a lot more narrowly tailored, a lot more specific. I expect that laundry list to either get, maybe there'll be some statutory or a common law decision that, encompasses more things, or it's just going to get longer and longer, and parties are going to want to make sure that they're protected by any possible thing that they can foresee.
I mean, I guess what I'd add is we have this, when we're talking about the laundry list of common force majeure events, we have the very common strikes, riots, acts of God, terrorist attacks. Those are the really, really common ones. I might be missing a few, but Olin, do you think that pandemic is just going to be slipped in there as a, going forward, not in the, not necessarily in the immediate future, but as far as the norm goes, do you think the norm will shift to add that in? I mean, how did all of these other events get added in? I would argue, right? How did those become part of the standard boilerplate?
Well, interestingly enough, the civil unrest and the Civil War clauses came in because we export a lot of our production to Africa and Asia, and those regions are most likely to have civil unrest. And so the American companies and the English companies who were contracting for these mass-produced goods found that they weren't getting their shipments on time because their labor force was out fighting. And so they needed to include that. And to answer your question, I do think pandemic will get included in some way or another. And I also think that the early attempts will be, although made to fix this current issue, still be overbroad, because I mean, I'm not a scientist. I don't know if I just say the word pandemic, to me, that's okay, that's COVID-19, coronavirus. What else falls into that? I don't know. So if I say that and then you agree, and then let's say there's a viral pandemic versus a bacterial pandemic, and then you say, well, we talked about a pandemic, and you're like, yeah, but you meant like a viral one, right? Not a bacterial one.
You mean like coronavirus, right?
Yeah, exactly. So I think it will ultimately be incorporated in one way or another, but I think there will be a few learning points and stepping stones before we get to one that is narrow enough to incorporate exactly what the parties want.
Yeah. And to your point, I can tell you that in the last couple of months, I have seen a huge uptick, and I know you have too, Olin, and my clients asking me to negotiate in, whether it's force majeure or otherwise, COVID-19 related protections. If there is some sort of delay, you know, I mentioned earlier, I do a bunch of commercial transactions. It's been relatively commonplace to now include a tolling or a delay clause that will kick in if there is an inability or a massive inefficiency related to performance under the contract. So just as a, you know, as a random example, you know, it's been more and more common to allow for day-to-day extensions of a closing date if you're buying or selling property, if that closing can't be performed because the title company is closed, or because they're overwhelmed because of having their workforce having to work from home, and they can't handle the closing, or the recorder's office is closed. So this is absolutely a you know, something that if you aren't dealing with it already, I can tell you that you probably should be. And if you aren't yet, you should be, and you will be in the future. You know, we don't know how long this is going to you know, necessarily go on, but long enough that when you're signing contracts now that have a life to them, you should be considering these things, I'd say.
Well, and I think if you're considering a contract that does have a life, it's not enough to say any disruptions due to COVID-19, because what happens 3 years from now when, you know, it's COVID-24 or some other strain or something else?
Sure.
And we talked about, you want to be really narrow because you want to be able to enforce it. And if I try to enforce that and I say, well, you know what I meant anything. And it's like, well, no, you specifically wrote this. That's why we agreed on this, because I was comfortable allowing a suspension based on this because I knew that wasn't going to be an issue in the future. So it's good that you're seeing that specifically to what we're seeing today. But I think, I guess almost walking back what we said, you want to be narrow, but you don't want to be that narrow where you box yourself into one specific thing. You want to be narrow enough.
Yeah. So I think and I interject if I'm twisting your words, but I think that the words that I would use to describe the clause in general, depending on what you want, again, depending on who you are to the contract, you're going to want a narrow or a broad clause, right? Yes. So that's how it will apply to things like COVID-19 versus COVID-2024, to your point. Right. But at so that's something that will shift depending on who you are. But I think in all cases, or almost all cases, you're going to want a certain clause, right? So then you have the other scale I would call, you know, certainty versus ambiguity. I think in all cases, regardless of whether you negotiate a narrow or a broad clause, you want a certain clause. You want to be sure of what you're agreeing to. So you want to take out that ambiguity regardless of whether you want broad, you know, whether you want it to cover COVID-19 and COVID-2024, or whether you just want it to cover COVID-19 if you want a narrow interpretation. I think you can have both broadness and certainty, I guess is my point.
Well, and I mean, you would know better than me, but I think if you wanted to have kind of that catch-all and the prospective future one, you would say any disruptions due to COVID-19 or a related, you know, nationwide, worldwide pandemic. And then you're covered, obviously, specifically for now, but also going forward, if an objective viewer then can say, okay, so clearly the parties disagree subjectively what they meant. What does a reasonable minded person think of when they hear COVID-19 or a related pandemic? And if that thing that's affecting the contract at that point to an objective viewer is that related pandemic similar to COVID-19, then you're not going to have a good day in court arguing that that's not what you thought that the parties meant.
Right. Yeah. Okay.
So before we jump into questions, let's talk about what remedies you do have if you are found in a position currently where you have no force majeure clause or a weak force majeure clause that doesn't protect you, but you want some sort of relief still. The first common law remedy is frustration of purpose, and that is defined through 4 principles. There's the principal purpose, materiality, non-occurrence of the event, and the party seeking relief should not bear the risk of loss. And I'm not really going to walk through each one of those individually, but I will give you a good example of what a frustration of purpose case looks like. And it's the seminal case here in the United States. It actually comes from an English common law case, part of two, the coronation cases, Krell v. Henry specifically. 1902, after Queen Victoria died, Prince Edward was set to be crowned king, and in London, they were going to have the coronation. Krell bargained for this majestic view from this pristine hotel that Henry owned, where the coronation parade would come through. You know, he said, I want the best room. I want to see this. This is super exciting to me. And so they agreed. I think he paid today's worth about $10,000 for the room and paid a third of that in his deposit. A few days before the coronation parade, Prince Edward had an appendicitis and fell ill, and the coronation parade was indefinitely postponed. Krell and Henry went to court arguing both sides of who needs to perform. And the court ultimately decided that the parties lie where they stay. Krell's deposit was forfeited, but he didn't owe the remainder of the rent or of the fee to Henry for the room, because it was clear to Henry that Krell's sole purpose for having that $10,000 room was to watch this parade. And although it was possible for him to still sit on the balcony and watch the street, the main purpose, the principal purpose, the material purpose of this contract was to watch the parade, not just an empty street. And so if frustration of purpose, if some of those elements sound like they may apply, then you may have relief under that avenue. Also, there's two similar but slightly distinct common law remedies of impossibility and impracticability. The impossibility comes into play with foreseeability. So if you can foresee something happening and you still bargain for it despite of that foreseeability, for example, you bargain with someone to watch your very sick and aging dog, and the dog passes away shortly before the the week vacation where the person's supposed to watch your dog, and they make plans to set their plans aside to watch your animal, and he passes away. That may have been foreseeable enough where the court would still enforce you to make the payment, even though there was no animal to watch. And then severity of performance comes into play when we talk about impracticability. And there's actually a decent amount of Arizona case law defining this. And it's basically impracticability is that it's so much beyond the party's contemplation that it becomes an exercise in commercial futility. So going back to the tornado case, we love bringing this guy up. Let's say that he could have rented someone else's boat to deliver these goods, but he stood to make $1,000 for the delivery, but renting someone else's boat on such short notice would cost him $3,000. Now, is it possible for him to still deliver the goods on time? Yes, but is it impracticable? Probably, because he's going to lose 2 times what he stood to make simply by performing on the contract. And so that's another element to look at in terms of if there is still the possibility of performing, but how detrimental and how much of a bottom line hit you take might come into play.
Yeah, and I think you said this at the outset, Olin, but just to repeat it for those watching, these are common law remedies that, with a really important note that they have a massively high bar for proof, of proof. As you said, commercial futility, impossibility. I've seen defined, at least anecdotally, as being, strictly impossible or legally impossible. Like, we're talking high bars. But when does this apply? I mean, these would apply potentially if you're looking at a contract and it doesn't have a force majeure clause that, I guess in 2 cases, it either doesn't have one at all, or it doesn't have one that could even potentially apply to the act for which you're seeking relief from. So in that case, that's where you would consider, potentially one of these 3 remedies. Yeah.
I think we can take some questions. I want to just point out, I think Dan said this ahead of time, any specific, I run this business, this happened, what should I do? We can't really answer those. That would be constituted as legal advice, but we are happy to answer broad questions and, if you want to try to trick us and say, oh, my friend has this, that will probably be seen through as well. But any any general questions or just follow-up questions, we are more than happy to answer.
Thanks, Olin and Dan. I think if you open the Q&A tool, there's a question in there that seems pretty general. If you guys want to take a look at that.
From David Graff.
Mark, can everyone see this one?
I believe so, but if you want to read
Okay.
it out, that'd be great too.
Okay, I'll read it out.
Pull it up on yours?
I think it's on the screen, yeah.
Oh, I'm
Or do you not
still
see it?
seeing the slide, but
Oh, okay. Maybe you don't see my Zoom tools.
So I'm fine, yeah.
Okay. So David asks, what types of examples based on contingent liability from unassumed past, present, future losses are you seeing with counterparties reverting to a force majeure clause? Are you saying an extraordinary event that results in a below the line economic impact has to be incurred and realized loss prior to legal action by one, both, or all parties to a force majeure, promissory estoppel, detrimental reliance act? So I think that as to the second part of the question, Olin, this is sort of litigation based, so you can obviously jump in. I would say that, force majeure is normally a retroactive approach, but it doesn't necessarily need to be. It can be proactive in the sense that you can, essentially assert, if I'll give you an actual example to explain this better, I think. So if I had a client that came to me that said, hey, Dan, I want to get out, or I need to get out from performing this act under this contract because I'm going to incur this massive liability if I do it, or I can't do it, right? I can't legally do it. I would most likely tell that person that depending on what the force majeure clause said, you'd want to prospectively assert that right and negotiate with the other side based on that right that you'd be able to assert to get out from under the performance anyway. So I think a prospective approach in that sense would be proper. Olin, do you want to jump in
Yeah. And I think we both have actually had this happen to us. And I think what we're seeing is parties are coming to us without the direct damages or the direct failure to perform having happened, but they are saying, hey, I'm a tenant. My job is stalled, or I've lost my job, or I have this 6-month lease and I won't be able to pay in 2 months. What do I do? And what we've both had success, you and I, Dan, on both the landlord and the tenant side, is we reach out to the other side and we proactively say, hey, we have this issue. This is the circumstance. We may have this clause that protects us. We may have these common law remedies that we can invoke. Let's avoid all that. Let's figure this out now. My client is 3 months out from having a potential breach. What can we do? And for one example, I had that exact example, 6 months left on the lease, and he had savings for about 3 months. They agreed to postpone the payments until he went back to work, and then my client agreed to tack on however long this forbearance period. So let's say it was 2 months before he went back to work. He would just add on 2 months at the end of the lease to stay in the property, and it's a kind of a win-win for both sides. So it's not required to have either the breach or the damages, but and I would actually take that back. It's not required to have the breach or the damages, and I would suggest you don't get to that point, because then there are actual legal principles at play, and you may be liable or have rights that you're sitting on that you may need to invoke, or you waive them. So
yeah, and I would just add one last point that in the event that there are some sort of damages incurred because of a force majeure event, and Olin, let's say you and I are contracting together and I'm delivering the goods on the ship to you, and I don't deliver them, and I don't prospectively take the approach to try to get out from performance based on the fire, right? Fire of the ship, on the ship. You could sue me for breach of contract, right? For failure to deliver the goods. And then I could turn around and say, and I could assert either the protection under the force majeure clause, that it wasn't a breach, or I could, in addition or in lieu of that, assert one of the three common law remedies we talked about as a defense, right? And say that hey, I couldn't perform. It was impossible to perform. It was impracticable because I would lose 3 times the amount or twice the amount that I stood to make in your example, Olin. So I think that, it can be certainly used. We've talked about this before, offline, certainly, that this can be used offensively or defensively. And you could have success in either case, I think.
Yeah, exactly. And I think just what you just said was really important, that you have to reach out once this happens. And going back to that sample one, I think it was the red highlight where you talked about each party shall notify when such party desires to exercise its rights under this paragraph. So the using it offensively or defensively, that requirement to notify, if you have this defense but you don't affirmatively use it, there could be an argument that you waived it because this provision said you have to notify me once you have this. And if you sit on your rent, don't pay. Landlord tenants, easy for everyone to understand, so I'll keep going back to that. If you sit on your rent payments for 3 months and then your landlord comes back and files a complaint, and you say, well, no, remember 3 months ago when this happened, I couldn't do it. And he says, yeah, but that's a great force majeure clause, but it also requires you to let me know that you're invoking it. You can't just say, oh, by the way, 90 days have gone by and now I'm invoking this specific thing that helps me because now you care.
Yeah. Olin and Dan, I had a question. So with regards to kind of the specificity piece and how some of these clauses maybe wouldn't have mentioned a pandemic or a viral outbreak, but I believe in the first sample you showed, there was something about kind of government mandated closure and regulation. So we have had kind of the stay-at-home orders and things like that. Are you seeing people use that component of a force majeure clause to kind of substitute, yes, there was a forced closure because of a pandemic, but it was still a government mandated thing, and that is in the contract? Have you seen that play out?
I haven't seen it personally, but we kind of touched on how that could be used to defend an absence of performance in light of COVID, because, if your performance or your company was subject to the closure, if you are an essential business and you had to stay open, then this doesn't even apply to you. And so, like we talked about, going back to the tornado case, if the party receiving the goods tries to say, well, your ship burned down, I'm not going to pay you, it doesn't work like that. These events have to actually apply to the party trying to invoke the protection. Yeah. But yes, if you're a non-essential, then absolutely, I would be happy making that argument on your behalf if you were a non-essential business and that was the clause you had.
Right. Yeah. And I'll tell you that I haven't solely relied on that type of provision, but I've used that as a piece of a multi-piece argument to say, hey, this is why my client should be excused from performance, or this is why we need to come back to the table and renegotiate terms because of what's going on right now. So it can be, it can be the sole or multiple pieces. I would also add, Olin, based on what you just said, I'm going to take issue with one thing and say that I think the even if you were an essential business, you could potentially have that clause apply to you, because it doesn't necessarily just apply if you're closed. It applies if there is a governmental restriction to how you operate. And even essential businesses, some of them had additional restrictions that applied. True. Think about when restaurants reopened or when restaurants were takeout only, right?
Sure.
That's a restriction that prevents you from operating as normal. And you could make that argument under that piece, even though you weren't technically closed because of the pandemic or because of the underlying event, if that makes sense.
Right. And then your defense kind of almost deviates into the whole analysis of impossibility versus impracticability and how much of a commercial hit you actually took. And, yes, we could make revenue and pay our employees, but we would have to have 8 times the takeout orders we normally did, and that's just unfeasible. And I agree that there is an analysis to be made. And again, I think that's kind of, for us, the fun with the law is we can take a weak argument and nitpick and pull out things that benefit our position and hopefully get to the result we want. I do want to say one last thing on on the that specific provision where it talks about delays due to strikes, riots. It could have protests in there. Kind of going back to what we talked about, obviously with the things going on recently. Let's say you own a business in Casa Grande that has been completely unaffected by the strikes and riots. It's kind of the same thing. Just because strikes and riots and protests may be happening in Phoenix, if you're off in a place where you're completely unaffected by this, you can't, again, call on that, well, this happened over there, so now I'm excused over here.
Got it.
Yeah.
One other question, kind of generalizing something that's in the chat, is who should have a force majeure clause? If you're creating contracts and having customers sign them, is that kind of a, yes, every contract should include this? Or is it sometimes opening them up to additional risk that they might not need to take on?
Yeah, I'd say that generally you're it's hard to put a blanket statement here, but I'll do it anyway. You're always going to want a force majeure provision in your contract unless there's a specific reason not to have it. And then, once you accept that fact, then break it down further and say, okay, now that we're there and we have it, do I want a narrow one or a broad one? Right. And from there, you can decide based on who you are to the contract. I see the question in the chat. I think it's going to depend on who performs the great majority of the acts. So if it's a service being provided, then if it's a service being provided in exchange for money being paid, the person providing the service generally wants a broader force majeure clause because they want an out. They want a potential out from performing that if they can't. But yeah, as in response to the general principle, I'd say, yeah, I mean, you want it in there because it's an additional protection that will stand to benefit both parties. And then the negotiation point comes in to say, how broad or narrow should it be?
Yeah, and I think this is a stem off of the question in the chat from JJ, and absolutely, if I owned or my friend owned an off-road tour company, I would want that provision in that contract because exactly what Dan said, you or your friend are the one who's doing most of the work. You're not the one paying someone. So most of the brunt or most of the impact by any sort of unforeseen circumstance will come on you rather than your client. And you definitely want to be protected.
The legal way to put it would be who should bear the risk of loss, right? And whoever's going to bear the most of the risk of loss will want protection. And that's what force majeure is intended to protect against.
Thanks, guys. We're at the hour, so I want to give you first say thank you for this great presentation. I feel like I just got my first credit toward a law degree. But if you have any kind of final thoughts or statements to close us out, would love to hear it, and then we can say thank you.
Go ahead, Dan.
Well, yeah, I just want to thank you, Mark, and ACA for having us. This has been an incredible series that you guys have put together, and I think really instrumental to the business community here and the greater community really in Arizona. So I commend you guys for doing that, and thanks for having us on. We have our contact information on the screen here. Should you guys have any questions, feel free to call us or shoot us an email. As we talked about today, and I'll apologies if it was too in-depth and too minutia at times. We tried to make this as general as we could. But I do think that this is an issue that is probably affecting everyone on the call. It's just whether you realize it is or not. And it's something I certainly recommend addressing prospectively in advance. Take the time to negotiate that point. Take the time to add that paragraph when you sign a contract. It's not going to shock the other side because it is pretty standard. So yeah, that's what I'd say.
Yeah, and just to piggyback off that, obviously, thank you again for having us. This has been fun. I know Dan and I genuinely enjoy just talking about this. So doing it for people who might learn something is an even bigger benefit to us. But yeah, it's important to have this clause. It's important to think prospectively, and I think especially for the audience, honestly, going into this presentation this morning, I wasn't sure exactly who the audience would be, but seeing that it is small businesses of 20 or so employees, I think like Dan talked about, you are more likely than not the party who bears the risk in these contracts. And so you definitely want to protect yourself, and you definitely want to take that extra, 10 minutes, an hour, whatever it is, to fine tune this provision to make sure that you're not spending a lot more hours with someone like me and Dan down the line.
Well, thank you both very much. For those still on the line, the recording and slides for this will be posted to our website. I just posted the link again in our chat. And be sure to look up in that website for future sessions that you might want to register for. A big thank you to Olin and Dan again for presenting today. And I hope to see you all again on a future session.
Thanks, Mark.
Thanks,
Thanks, everyone.